want to begin this lecture by asking you two questions. First, can ideas be a form of property? Second, if someone steals your idea, can you sue them for compensation? Hello, my name is Dr. David Monkton, Lecturer Agribusiness, University of Tasmania. I've prepared these lectures with material supplied by Dr. Greg Clydesdale, Senior Lecturer, Lincoln University, New Zealand. The fact is, you cannot sue someone for stealing your idea unless you've put it into some tangible form. Imagine you are having dinner and you see a movie director. You go up to him and you say, "I've got a great idea for a movie." You then tell him the idea. 2 years later, he makes a movie that is very similar. If you sue him, you will fail. How do you know that he didn't already have the idea, or that other people had the same idea? More importantly, a movie script consists of more than an idea. It contains conversations, scenes, and treatments. In other words, an idea in itself is 1, hard to prove its origins, and 2, very simple. If you approach a director while he is eating dinner, he will most likely tell you to go away and write the script. Once the script is in a tangible form, you can be legally protected and you can sue him. These questions lead us to the concept of intellectual property. There are 5 forms of intellectual property that we'll talk about in class: copyright, patents, trademarks, registered designs, and plant breeders' rights. In this lecture, we will cover intellectual property aspects relating to patents, trademarks, and copyright. What is a patent? A patent provides protection for inventions and processes with industrial applications. A patent is a right granted for a device, substance, method, or process that you have invented. It is legally enforceable. It gives you the exclusive right to commercially exploit your invention for the life of the patent. I provide an example in this slide, which is the recessed cutter disc for lawnmowers. In 1975, the rotating blade unit for the lawnmower was invented by Dolph Henry Meyer and Edward Henry Sykes and was subsequently patented. What are the trademarks? A trademark is a way of identifying a unique product or service, sometimes called a brand. Your trademark is your identity, the way you show your customers who you are. I provide an example in this slide. The brand Victor was first trademarked in 1954 by Victor Limited. What are design rights? Design rights protect the visual appearance of a product, but not the way it works. The example provided in this slide is the pink iceberg rose. I will now talk about copyright to introduce some of the concepts of ownership, exclusive rights, and licensing. What is copyright? Copyright is the intellectual property form regarding literary works, dramatic works, musical works, artistic works, and can include films, sound recordings, broadcasts, and published editions of works. In Australia, the copyright lasts for 70 years after the author-owner's death. How is your copyright protected in law? Copyright law is the law that protects your creative and artistic works, whether it be music, recordings, books, videos, photos, paintings, movies, etc. In Australia, this is covered by the Australian Copyright Act 1968, with some subsequent amendments. One of those amendments was the Copyright Amendment Act of 2006, which said a copyright of a work exists for 70 years after the death of the author. It used to be 50 years. Copyright law gives you the chance to earn money in a number of ways. I will talk about that in a moment. Who owns the copyright? The author or person who created the IP owns the copyright. But if you were employed to make the work, it is the employer who owns it. Copyright generally belongs to the author or person who made the work. However, if you were employed to make the work, it is the employer who owns it. Herein lies a warning. If you are subcontracting or have been subcontracted to make a work, Make sure your contract says who owns the work once made. Otherwise, you might be caught in an ugly legal battle. How does copyright protect you? Under the Copyright Act, it says that if you are the owner of a work protected by copyright, you have exclusive rights to use your work in certain ways. This means that you are the only person who can copy or reproduce the work, make an adaptation of the work, publish it, perform it in public, and broadcast the work to the public. You also have moral rights to be recognized as the author of the work and to object to derogatory treatment of the work. Copyright, like other forms of intellectual property, effectively gives you a monopoly to use your work. It gives you exclusive rights to reproduce the work, publish it, or if it's a stage piece, perform it. You will be recognized as the owner, and you can object if the work is used in a derogatory manner. Under copyright law, you have exclusive rights to use your creative work, but you are not always in a position to take advantage of those exclusive rights. In these instances, you can grant a license to someone or some organisation who does have the resources. For example, if you've written a musical, you might not have the resources to stage the play, in which case you can give a copyright license to someone. That person will stage the play and in return will pay you a royalty fee. You can give that person, the licensee, a limited license that places limitations on the licensee, perhaps allowing them to use your musical piece only in a certain area or certain time. You have the choice of granting exclusive and non-exclusive licenses. A non-exclusive license means you are giving someone the right to use your work, but that does not stop you from letting other people use your work. If you give someone a license to use or perform your work, you should both sign a license agreement outlining what rights you are giving to the licensee and what you expect back in return. Of course, if you don't have the capabilities to exploit the work, you may give someone a license to publish or perform your work, and they will pay you royalties in return. This is useful if you won't have the finance or resources to make full advantage of your copyright. You can give that person, the licensee, a limited license that places limitations on the licensee, perhaps allowing them to use your musical piece only in a certain area or certain time. You can also give them either an exclusive or non-exclusive license, which determines whether you can give licenses to other people or not. An exclusive license only allows the person or organisation you have given the license to the right to use the work. You are giving them an exclusive right to use your work. On the other hand, a non-exclusive right means you can give licenses to other people as well. Thank you.